Welcome everyone to the fourth episode of this podcast series called Environmental Justice Litigation. This podcast series is part of the students project at the University of Oslo. My name is Iva Svalina and my co-host is Konrad Sandvik. Konrad, who are we speaking with today?
Well, today we have secured an interview with Beate Sjåfjell. She's a law professor at the University of Oslo, and her expertise is within business law and sustainability. So she has done a lot of important work within social foundations and planetary boundaries, and we hope she can relate her work in these areas to the Norwegian climate lawsuit. So without further ado, I think we'll just roll the interview. So today we are joined by Beate Sjåfjell. She's a law professor at the Faculty of Law at the University of Oslo, and she's an expert at business law and sustainability. So thank you so much for being here with us today, Beate.
My pleasure.
Thank you for being here, and we can start immediately. Can you tell us what the Norwegian climate lawsuit was from your perspective and how it unfolded in the courts?
Yes, I will be happy to do that. It was the first climate lawsuit in Norway where environmental organizations sued the state when they opened up a new round of licensing in the Arctic, a new round of licensing for oil and gas exploration in the Arctic. And the environmental organizations argued that this was a violation of the right that the Norwegian Constitution gives us all to a viable environment for us and future generations.
Yeah, so that's a great summation. I was wondering if you could explain a bit more just what the Section 112 establishes and what in your opinion, and what the Supreme Court found that it establishes, or how they interpreted it.
Yes. The Norwegian Constitution, Article 112 in the first provision, gives us a clear right to a viable environment for us and for future generations. In the second provision, it gives everybody in Norway a right to information so that we can pursue that right. And then in the third provision, it says that the state shall ensure that these provisions are followed up. That's not a direct quotation, but just an explanation of the content. This last provision was changed in 2014 when there was a general revision of the Constitution, where we got a new chapter on human rights, and the environmental provision that we had had since 1992 was then placed in that chapter on human rights. In my opinion, the change in the last provision of Article 112 wasn't really a strengthening of the provision, it was more a clarification of the content. But for all of those who had feared or argued that Article 110b, as it was called before 2014, that it didn't give people in Norway a right to pursue this provision before the courts, that really strengthened the provision, because the third provision of the article went from rather vague wording that made it clear that it was the state that was to do what had to be done under that article. It was then clarified by including the word shall. So that was a major change, in my opinion, clarification, and for those who didn't see it beforehand, a strengthening, because it was then set out clearly that the state shall follow up these provisions. And importantly, the committee that prepared this proposal for the parliament, they wrote very clearly that this was done to make it clear that the state has a duty to do what is necessary to ensure that we all have a viable environment, both those of us who are living now and future generations. But the Norwegian Supreme Court, when they discussed this, they somehow evaded the whole issue by by quite evasive language around these changes without going to the heart of the change that was made. And this is especially clear in the English translation of the judgment, where they used shall both with reference to the old provision and to the new one. So they managed to dilute the whole change of the provision and make it sound like there wasn't really anything that was meant to be changed or strengthened or clarified in the provision. They refer to it as just a pure linguistic change. So that is very misleading in my opinion, because in my opinion it was clear already from 1992 that the environmental provision in the Constitution was meant to have legal significance, because the Parliament rejected adopting a provision, an article in 1992 that would be a mere political statement. They didn't want that in the Constitution. So they adopted an article that was meant to give a clear legal right to us in Norway. But unfortunately, many lawyers tend to be very backward looking when they analyze law. So when legal scholars were asked whether this provision could give anybody a right, then they looked backwards at the decisions that had been made by the court and said, no, we haven't had any such cases, so it isn't a right. Which is a fallacy, a logical fallacy in itself, because there always has to be one case that is the first case. And if you say in the first case that this isn't a right that can be pursued before the courts because we haven't had any such cases, then you will never have a right that can be pursued before the courts. That was the first logical fallacy that has been made in the interpretation of the environmental provision in the environmental article in the Constitution. The second one is concerns the fact that the environmental article clearly gives the state a lot of discretion for how to ensure that we have a viable environment. That is also very understandable. It would be strange if it was set out in one environmental provision in the Constitution exactly what the state should do decades ahead. So there is discretion for the state to decide how to do this, which is also important for the state to have, because the state has to balance a lot of different interests. But if the state doesn't protect the environment to a sufficient extent, then it will go beyond that discretion that the article gives it and violate that provision. And in my opinion, it is obvious that that is what the state has done here. But in the discussion about the environmental article, somehow a leap has been made from, okay, so it's up to the state to decide how it will do it, to become, so it's up to the state whether it will do it. And that's comparable to if you see a burning house and the fire department has rushed out to this burning house and they are standing there looking at it and just talking. And you go up to them and say, what are you doing? The house is burning. Why aren't you doing your job? And then they say, well, it's up to us how to put the fire out. And yes, that's obvious, but you're not doing anything. Well, it's up to us how we do it. So that's what's happened in this situation, which is why it was so important that the clarification was made in 2014, that it is a legal duty. And of course, you can imagine a legal duty where it's not possible for anybody to go to court and say that the rights that I can draw from this legal duty that the state has been violated, that they cannot go to court and say that. But an environmental article in the Constitution that sets out a right for us and a legal duty for the state to follow it up, of course, also needs to be possible to pursue before the courts.
Yeah, and in this specific case, of course, the issue was regarding the giving out of oil licenses in the North Barents Sea, and whether drilling for oil should be something that the government keeps on doing if it has a duty to protect the environment according to Section 112. So you've talked before about planetary boundaries, and could you put that work into perspective in this case as to whether the government should keep drilling for oil?
Yes, I will be very happy to do that. Thank you for that question. Because in the discussion from 1992 to 2014 about what this environmental article in the Constitution actually means, one of the problems for legal scholars analyzing it, including Ole Christian Fjell, who did a very good job in an extensive article analyzing the legal status here, was that it was difficult to say what are the limits, what are the minimum requirements that the state needs to fulfill if it is to be able to say that we have done what we were supposed to. We have done the minimum that is necessary to do to ensure a viable environment for Norwegian citizens now and future generations. This is something that Ole Christian Fjell discusses in his article, that it's difficult to find these guidelines for what are the minimum environmental provisions. But what we can do, and what I have done in my own work on this, is to look beyond the law and look at natural science. Because if we're going to understand what is the minimum that we need to do to ensure a viable environment in Norway and on this planet for humanity, we need to look at what natural science is saying about this. And natural science has developed a lot in this area since 1992. And in the groundbreaking article in 2009 with Professor Johan Rockström, head of the Stockholm Resilience Center then, as lead author, these limits were actually identified. Rockström brought together environmental scientists from different fields in different parts of the world to, for the first time, identify where these limits are that we all intuitively understand must exist. We all intuitively, if we think about it, understand that there must be limits to how much we can take out of nature and how much we can dump back into nature, whether it is in the ground or fresh water, seawater, or the air, and still expect the planet to be a safe space for humanity. And that's what Rockström and his co-authors did in 2009 in the article Planetary Boundaries, a Safe Operating Space for Humanity. They, for the first time, identified 9 Earth systems that we need to avoid messing with if we want the planet to continue being a safe space for humanity. And climate is one of them. So it is obvious then from natural science that staying within certain limits of disruption of the climate is one of those minimum requirements that we need to stay within. There are also others. So this is also relevant to what Norway does and doesn't do when it comes to biodiversity. But let's stick to climate now.
But
so,
sorry. No, continue.
Yes. No, so on the one hand, we have the natural science that says that we have to stay within certain limits when it comes to climate change if we are not going to disrupt the very basis for a good existence for humanity on this planet. And climate change is also one of what they refer to as core boundaries. So while all of these Earth systems interconnect with each other and influence each other, climate change is a core boundary, which means that pushing that boundary, transgressing that boundary, is enough in itself to disrupt the relatively stable state we have had on this planet for the last 12,000 years. So that's the natural science part. And then we, in addition, have a global political consensus of where this boundary should be. And that is based on and on natural science at the time, and it could be argued that maybe the goals that are set out in the Paris Agreement of aiming to stay within beneath 2 degrees warming compared to pre-industrial states, and preferably between 1.5% warming, that is maybe not even enough, but certainly we can say we mustn't go beyond that. So there's a global political consensus which Norway has been an advocate for and signed up to. Norway has signed up to the Paris Agreement, of course, and Norway has also signed up to 2 different declarations saying that Norway wants to be a leader in this area, wants to be a coalition of those that go ahead and make sure that the world works to fulfill the Paris Agreement. So the Norwegian government, the Norwegian parliament has shown its clear commitment to staying within the Paris Agreement goals, and we have a very clear natural science basis for saying we really have to do this, because otherwise it risks disrupting the very basis for a viable environment for us and for future generations. So it is so clear that when the Norwegian state then continues to hand out licenses to explore for more oil and gas, when we know that most of the hitherto identified reserves of oil and gas need to stay in the ground if we are going to have even a chance to achieve the Paris Agreement goals, then of course Norway is going beyond what it has a discretion to do. It's not a balancing act. It is a clear violation of the Constitution, a clear violation of the purpose of the Paris Agreement. And Norway, the Norwegian state is doing this with so much newspeak that it reminds me time and time again of George Orwell's 1984.
And what you mentioned and what is interesting is that the Supreme Court mentioned IPCC scientific reports in the judgment, but still they didn't conclude anything regarding them. They just ignored it.
Yes.
And also before that, you mentioned rights of future generations, which are also explicitly mentioned in Article 112, which also weren't touched upon in the judgment at all. Which brings us to the next question regarding the impact assessment. Can you comment on the impact assessment? There were some parts which were disputed, for example, combustion emissions abroad, which weren't included and should have been included based on some of the Supreme Court judges. But what else was missing in the impact assessments from your opinion?
Yes, thank you. Yes, the impact assessment before the opening up of the 23rd round of licensing was shockingly weak. I had heard before I went through and assessed these impact assessments in detail, the argument that made that environmental impact assessments are only made to support a decision that is already in place. So you know that you want to do something, and then you do the impact assessments, and then write the decision so that it somehow fits with these. I didn't think it could be that bad, but my assessment of the environmental impact assessments made by the Norwegian state was that it was even worse. And I know that there are natural scientists that are frustrated by being asked again and again to produce reports on what impact will an oil spill have on bird life in this region, for example. They submit the same reports again and again, and it is very clear from the wording of the impact assessment that there was no proper assessment of whether one should open up this area or not. The only discussion was how it should be opened up. So, okay, so there is a risk of local pollution, so then we must be careful when we open up this area. When it comes to climate change and the impacts that continued oil and gas exploration under the auspices of the Norwegian state has, that was just deferred to a discussion that happens elsewhere. They didn't go into the climate impacts. They said that this is a discussion for elsewhere. And I tried to follow that lead, and I didn't find anything that was relevant to the impact assessment where they really discussed what this means. And according to European Union rules on impact assessment that Norway also obligated to follow, one is meant to assess the impact of one decision on the environment in the context of other decisions that are also made. So if something is on the breaking point, then you can't say, well, our activity will just be a very small contribution, so that's fine. If you can see that our contribution will maybe be that last drop that brings this beyond the breaking point, then according to EU law, you're not allowed to do it. Norway didn't go into that. And also Norway didn't assess the effects on the indigenous population at all. There is also an article in the Norwegian constitution that gives indigenous people's rights and is meant to ensure that their interests are considered. This was also just ignored.
Yes, you talk about having to think about stuff as breaking points, and can you think of global climate like that, or is it too hard to say that our emissions will have anything to say? You know, critics will say that Norway is a small country, our emissions don't really change the world emissions, and us selling more oil will give a lot of substantial benefits for Norway and not really impact the global climate that much. And if you talk to some expert, they will even claim that Norwegian gas will help reduce the global climate change. Can you comment to those points?
Yes, I'll be very happy to do that. Norway is one of the largest producers of fossil fuels in the world. So Norwegian fossil fuels contribute to climate change. That's the one thing with the direct contribution. And then secondly, Norway is a not insignificant global actor. So as long as Norway continues with this newspeak saying that, yes, we must achieve the Paris Agreement goals, yes, we must achieve this green transition and limit global warming and reduce fossil fuel emissions, and we will do this by continuing with oil and gas exploration because that is so important to give the poor people in Africa energy, and gas is better than coal, never then explaining why do we need the oil. As long as they continue with that, how can Norway then, as one of the richest countries in the world, expect other countries to say that, okay, we won't continue with oil and gas exploration, we will do what is necessary? And conversely, if Norway, as one of those that has gone out and said that we are going to be one of the front runners to achieve the Paris Agreement, if they have gone out and said, okay, what they should have said several years ago, we are going to stop oil and gas exploitation in the Arctic, because that was the obvious first no-brainer, that when we cannot exploit all of the oil and gas that is possible to exploit, the obvious things to cut must be oil and gas exploitation in especially vulnerable areas like the Arctic. Secondly, we will ensure that we are not, through Statoil now, Equinor, involved in especially climate harmful and environmentally harmful projects like the tar sand exploitation in Canada. And then after they'd done that, they could have said, okay, and now we are going to make a plan to wean Norway off oil. The argument that is often made then by people who just want to continue is, oh, but it would be a catastrophe if we just turned everything off overnight. Nobody has said turn everything off overnight, but the longer Norway waits to make this transition, the more abrupt it will be also for the Norwegian economy. And the Norwegian Supreme Court, the majority of the Supreme Court said that while Norway should have done a better impact assessment, they can do that later on in the process. But if they really meant that, I don't think they would have said that, because that will be more harmful for the state to do it later on. Because the later on in the process they do it, the greater is the risk that they will be sued by companies that have been given these licenses. So there are so many false arguments and so much newspeak in this that it makes me extremely frustrated as a law professor who takes the Constitution seriously, who takes environmental science seriously, and who takes the role of the Norwegian state in the world seriously. It makes me extremely frustrated to see how this country that once was an environmental leader and the country that gave the world if not the concept itself, brought attention to the concept of sustainable development through Gro Harlem Brundtland's work in the World Commission for our common future. This country is destroying its own its own reputation, and contributing to destroying our possibilities for a safe and just future.
So I, of course, really sorry, Iva, but I, of course, really agree with your arguments here. So I'm just wondering, those points that you're arguing are really close, or even going over the border into political arguments, like a political debate that's being had in Norway at this point, where there's still very far from agreement, where the majority of the country seems to still be wanting to keep drilling for oil. So how could the court come in and sort of overrule the will of the people or parliament when it comes to these things, whether Norway should take a more active place going forward and whether we should stop drilling for oil?
That's a very good question. Thank you very much. So an argument was made against the climate lawsuit already before it was brought, that it would be undemocratic, because it's up to the parliament to decide. If the parliament has said yes, then we cannot go to the courts. That is a false argument, in my opinion, because we have a division of powers in the Norwegian society, as in many democracies around the world, where the government has its role, the parliament has its role, and the courts have their role. And the courts are a very important safety valve. If something has gone totally wrong in the government and parliament, the courts are where we can go in a democracy. If we cannot go to the courts, and if the politicians that are elected don't rectify the damage that has been done, what are people meant to do? I mean, the Extinction Revolution has been called a very undemocratic organization. But while I might not agree with everything that they do and say, I totally understand the frustration that organization is informed by. So it is very democratic. It is a part of our democratic system that we can go to the courts and be heard if we believe that the parliament has violated our rights. But the Supreme Court of Norway, the majority, decided to let everything be decided by the parliament. So if it's been decided by the parliament in some way, then we don't really want to intervene. But what they didn't, first of all, I think that's wrong in itself, because the court there undermines its role as a guardian of the Constitution. And secondly, what hasn't then really been brought into that argument is the fact that the parliament didn't have a good basis for its decision, because the impact assessments were so weak. So when the parliament based their decision on that, they were basing it on flawed premises. And if I'm not mistaken, there has been a poll saying, showing that the environmental concerns in the Norwegian population are rising. But even if the argument could be made that most Norwegians want the Norwegian state to continue with oil and gas exploration, I don't know if that's true, but if we say that it is true, then that is also based on the same faulty impact assessments, because the Norwegian community as a whole doesn't really know what a bad basis there was for this. Plus, we are not Switzerland. We don't decide in all important questions by popular vote. We decide them by electing a parliament that is meant to ensure that our rights are protected, and the government is meant to execute the decisions that will follow our rights, and the courts are meant to protect us if something goes wrong. But this whole political argument is also an argument against any kind of change. And that's also a fallacy that I see a lot in legal political discussions. So if we talk about changing things, then it's political, then it's radical, then it's activist. But if we talk about continuing exactly as we have been doing and not changing the law, not changing policies, then it's all good. That's neutral. But law is never neutral. Law is never value neutral. Law is always the result of political struggles over time. And if we are not willing to discuss changes, and if the court is not willing to take on itself the role it has as a guardian of the Constitution, then we will have this continuous perpetuation of wrongs.
Were you surprised by this decision?
No, I was not surprised by the Supreme Court decision, because I know that the Norwegian Supreme Court has a reputation for being state-friendly. And I also realized, as I wrote about in my article on the legal status of oil and gas exploitation, the case of Norway, that there are many psychological factors that also make it difficult for judges to take this kind of brave first decision in a country. I thought it was an open question, but I was very, very disappointed by the way that the court argued, because they could have gone into the case much more thoroughly and made a much more open assessment of the case. And in my opinion, if they had done that, they would have found for the environmental organizations. Because in my opinion, it is an obvious case of violation of the Constitution, what the Norwegian state is doing. But I got a really bad feeling already before the court tried the case, before the Supreme Court tried the case, because 3 judges were disqualified from the case, 3 women, with varying argumentation. And it might have been right to disqualify at least all of them. I don't think it was right to disqualify all 3 of them. And I note that there was no similar discussion of whether judges that had a close connection to the state in their previous jobs or in any other way, whether they should be disqualified. If we'd had the discussion, maybe we wouldn't have been able to have enough judges to decide the case. So if we weren't going to disqualify judges who had a close connection to the state, how could we then disqualify a judge that had been involved in an environmental organization in her youth? So that gave me a bad feeling to start with. And I must say also, although that was not a decision that was made in this case, I wish that Arnfinn Bårdsen, who was on leave to be a judge in the Court of Justice in the European Court of Human Rights, that he had been in that case. Because I think that he has much more progressive and open views on the role of the courts in these kind of cases than many of the others had. But I think the majority of the Supreme Court, they failed their role, and they did it in a way that made me lose all respect for them.
So you talked about the Supreme Court being historically state-friendly, and I was wondering if you could touch a little bit on the history of the Norwegian Supreme Court overruling the state in any cases, and also if you could comment on the general harshness of the decision, like how high standard they put in this case, and it's, for instance, almost as to defang the Section 112.
Yeah, so the Norwegian Supreme Court has historically been seen as very state-friendly, which is easy to understand based on the facts, because most judges used to come directly from other positions in the state, like they worked in the Ministry of Law, and then they became Ministry of Justice, and then they became Supreme Court judges. That fact has changed a bit over the last years, so there is now a more varied basis amongst the judges in terms of their previous jobs. But I fear that also judges with different kinds of backgrounds, that they have been socialized into a Supreme Court that has state friendliness integrated in its core. And although we have had some cases where the Supreme Court has found against the state and for example, a private person, there has been discussions, and there has also been some research done on this, that the Norwegian Supreme Court tends to find for the state. When it comes to this case in particular, I think that the Supreme Court has continued on the same track as the Norwegian state has done in general, by using the same kind of arguments that avoid going into the case as such. They found it too difficult to deal with. They were probably too worried about what the consequences would be for the Norwegian economy, and they didn't dare to do their jobs properly. That is why I have lost my respect for those judges who were in majority.
But can we compare this case to the Norwegian Hempel case? With Hempel cases, we saw in those cases that it's possible for the courts to be a powerful tool in environmental fights.
Yes, that's a very interesting comparison. So in the Norwegian Hempel cases, the Supreme Court showed that it can be a guardian of the environment. But the Hempel cases were not a case between environmental organizations and the state. It was a case between the environmental branch of the Norwegian government, to simplify it a bit, and a Danish parent company, Hempel. So the case concerned probably totally legal pollution of the ground that was done by a paint factory over 100 years ago at least. That paint factory or its predecessor was later controlled by the Danish parent company Hempel. And in that case, the Norwegian environmental authorities went to the parent company and opened a case against the parent company, because they saw that that was where there was money to pay, first of all, for finding out the extent of the pollution of the ground, and secondly for cleaning up that pollution. The Hempel case in 2010 is a very, very interesting Supreme Court decision. And although we don't know what kind of significance that had, there were only female judges, if I remember correctly, or at least a majority of female judges. I think it was five women who decided that case. And they had in that case a very open discussion of the importance of allowing limited liability companies, which gives a limited liability for shareholders. So in this case, a parent company that as a starting point is not responsible for the debts of the company, in this case, the subsidiary, on the one hand, and on the other hand, the societal interests of protecting the environment. So they had a very open discussion of these principles, of these economic objectives, these social economic reasons for having limited liability companies, which have been so important around the world for developing industry, and the importance of protecting the environment. And they found that the Danish parent company Hempel, who had not been involved in the pollution of the ground because they came in as a parent company after that pollution was concluded, that they were responsible to pay the cleanup costs. So that was a very brave decision and a very interesting decision. And compare it to the plenary decision of the Supreme Court in the climate lawsuit, we see that the court can be a guardian of the environment, but apparently not if it has to do that to the detriment of the Norwegian state.
Yeah, and it's funny you brought up the all-female panel there. So I was wondering if you could perhaps relate that to your work on gender diversity in boardrooms, and maybe put it into perspective as to what role corporations and boardrooms and shareholder activism can have in the way forward against climate change.
Yes, so one of the interesting things that the Norwegian state has done when it comes to business is to adopt a rule that makes it obligatory for all public companies to have, to simplify it, 40% of each gender in the boardroom. And that was a legislation that was there were a lot of protests against it. It was seen as very controversial at the time, but it was adopted and implemented. And as a result, we have much more gender diverse corporate boards in public companies in Norway than we had before that legislation. And there we again see Norway's role as a global actor, because that legislation that was implemented around 15 years ago, that has sparked an international debate around the world, where country after country has considered including similar provisions. Often they do it in a weaker way than the Norwegian legislature did, where it's actually a duty that can be enforced. But it has really changed things around the world. And I think that is important in light of the fundamental transition that our societies need to go through, where business also has a key role. Not because I believe that all women are more long-term in their thinking and think more about people and the environment when they make business decisions, and nor do I believe that all men only think about short-term, narrow maximization of returns for investors. But I believe in breaking up groupthink. And to put it a little bit to a point, when I've spoken about this legislation internationally at conferences and so on, I've said that the result of the legislation was that white middle-aged men from Oslo West were replaced by a more diverse set of women. And I believe it has that breaking up of the groupthink effect. And I believe that we can also see that same kind of effect in the courts. So law has been very male-dominated, and bringing in more women then opens up for different types of thinking. So I think it's important, but I don't think it's enough in any way.
Could you also maybe talk a little bit about your work on profits and shareholders and the status of shareholder activism?
Yes, so what we are seeing, well, I can maybe start by saying that what I have found in the comparative legal analysis that I've done with many colleagues around the world is that a main barrier to business shifting over to a more sustainable way of operating is what we refer to as the shareholder primacy drive. And by that we mean this very strong social norm that says that shareholders own companies and that it is the duty of the board and by extension senior management to maximize the returns for shareholders. This is a social norm that has become so strong that it has become a legal myth. So many think that is what company law says. It isn't what company law says. Company law gives a lot of discretion to boards and management to decide how business should operate, but the social norm has taken over that space. And there is an emerging recognition also in finance, also amongst investors, that focusing on short-term maximization of returns in the narrow way that it has been done is bad for them too. So it is the financial risks of unsustainability are increasingly being recognized. So shareholders are now being more active in general meetings and in direct conversations with boards and senior management, and asking business or demanding that business be more sustainable. Both because they more and more realize that if we continue on the very unsustainable path we are on now, we risk societal collapse. And in societies that have broken down, there is very little hope of stable and good returns on investments. And of course, many of these shareholders, they care about the environment because they care about people. They have some of those old white men that have been sitting on in various decisions of power for a long time. They have grandchildren and they start thinking about what kind of future they are leaving for their grandchildren. So there are many reasons for this shareholder activism for sustainability that is emerging. And it is a driver, but it isn't enough. And we need more change within business and within the decision-making that is made on behalf of some of the most powerful investors that aren't physical persons, but that are large pension funds and other forms of institutional investors. We need sustainability really integrated into their decisions. So there are a lot of positive signs that the need for this fundamental transition, that it is more and more understood. But if I were to sum up the status now, I would say that there is too much talk about sustainability and too little actual action for sustainability properly understood.
And mentioning the corporate sustainability brings us to our next question. We have seen this year that the District Court of Hague ordered Royal Dutch Shell to reduce its CO2 emissions by 2030 as compared with 2019 levels. Do you think that this decision could have significant consequences for other companies that have significant CO2 emissions?
Yes, the international trend of lawsuits against both state and companies is a very good example of this, these risks of unsustainability that are being realized. So people and organizations around the world are using the courts as the safety valve to try to achieve a sustainable future. And although many of these cases are rejected for procedural reasons, and some cases that are not rejected for procedural reasons are lost by the environmental organizations, as we saw in the Norwegian climate lawsuit so far, there are also cases that are won, and some of them are really groundbreaking, like the Dutch Shell case. The Dutch Shell case is a very powerful example, not only because it says that Shell has to reduce its climate gas emissions, but also because it goes beyond the one legal entity. It doesn't say that the one company in the huge corporate group of Shell companies needs to reduce its climate gas emissions, but it says that the group as a whole needs to do that. And this is happening in various sustainability cases around the world, that this the protection that the principle of limited liability has given to shareholders, including to parent companies, is being broken through by brave courts. So we are in a phase where things are changing very rapidly, and I'm hopeful that they will lead to sufficient change for sustainability quickly enough. Also because people in business, thought leaders in business, are seeing all of these changes that are happening. They're seeing the changes that are happening in environmental, in natural science, in the natural environment. They are seeing the changes that are happening in the courts. They are seeing that country after country is actually making some changes in the legislation, like even Norway has done with its Transparency Act, to change the legal infrastructure for business. And they are increasingly realizing that they need to work with policymakers to try to get a good legal infrastructure into place if they are going to have a level playing field for business that contributes to the transformation to sustainability for the sake of the world and for the sake of their own business.
So contrasting this to the Norwegian climate case, then, I am no legal scholar, but I feel that the language of Section 112 is really clear in what it tries to establish, and yet the court dismissed that right. How would you compare that to the climate activism in other countries? Do they have such clear language to go after, or are they breaking through in the courts even though their language is not as clear as we have?
Yeah, that's a very good question. I think we see here how law can be really powerful or it can be meaningless. So you can have a really clear provision in the Constitution, but if the courts don't protect that, then it's meaningless. And then you can have less powerful language, and the courts can interpret that and fill it with content so that it becomes powerful. And Norway is not doesn't have the only constitution in the world that is powerful when it comes to environmental protection and sustainability. South Africa is, for example, another constitution, another country that has a powerful constitution, and that has also where the courts have also seen their role as a guardian of the constitution and protected it. But we're seeing development, country after country is getting stronger constitutions when it comes to environmental issues. So there are a lot of things going in the right direction, but it's not a seamless path towards sustainability. And unfortunately, the Norwegian climate lawsuit is an example of a quite serious bump in the road when it comes to trying to change things in Norway.
Since we are approaching the end of the interview, we wanted to discuss in the end about the legal system's role in climate activism and what are the benefits and limitations of using the legal system as an activist tool.
Yes, thank you. Thank you for that question. So I think if we look into the future and imagine that we have achieved sustainability, then it's going to, there has been a jigsaw puzzle that has been put into place. And legal activism is one of those pieces. So I believe that the international trend of lawsuits against both states and business plays an important role. But I don't believe that we can achieve sustainability through the courts only, for a number of reasons. It's expensive and time-consuming, and in some cases also risky to go to the courts. And although a positive decision by a court can have very broad knock-on effects that can protect the environment much more broadly than the individual case. As a rule, court cases deal with one individual issue, and it would take too long for the world to shift towards sustainability by trying every aspect of the unsustainable societies that we are in now, case by case in the courts. But it is an important piece. The political system is also another important piece, and I keep hoping that we will see more really groundbreaking shifts in political elections than we have seen in Norway so far. General activism by various organizations is also an important part of that, and the media plays a super important role. The media is increasingly, although it is still too much caught up by this, we're going to give both sides of the story, but they are increasingly seeing that they need to be clear on what the science says and not give this false impression of a debate by referring to what 99% of scientists say, and then by some rather crazy people trying to argue against it. So the media plays a role, but as with all systems, the media isn't playing its role well enough. Business plays an important role. Up to now, it has been mainly playing the role of keeping us on a very unsustainable path, but we are starting to see change there as well. And academics play a role. So academics need to go out of their comfort zone and dare to speak truth to power, even if they are then accused of being political or activists or communists, or to mention just a few of the labels that have been attempted pinned on me over the years.
I was going to say.
Yes. But I mean, there is a major change. I've been working in this area since I started on my doctoral thesis in 2003. When I started working on that, I was told in no uncertain terms that you cannot write a doctoral thesis about European company law, and include anything about the human rights and the environment. You're in the wrong department. It's the wrong topic. Nobody has done that before. Again, this backward looking, nobody has done it before, therefore it cannot be done, which also illustrates the silo thinking in much of law and policy and politics.
That is amazing.
Yes. I invited the professor who said that most clearly to me to my doctoral dinner, and said that there are two ways of inspiring me. One is saying, good, keep going, and another one is saying that you can't do that, it's impossible. So I thanked him in public for inspiring me in the latter way. But I have been regarded as being on the fringe of company law in my emphasis on sustainability. Also, when I have done groundbreaking or coordinated groundbreaking comparative legal research across jurisdictions. But this has changed really over the last few years. I'm now, I think, as the first Norwegian on the European Commission's expert group on company law, which is a reflection of the work that my research group and I have coordinated in these areas. So there has never been more attention to these issues than there are now. Now we just need for that to be taken seriously and followed up all over the board.
We'll cross our fingers for that to happen, of course. So I think it's been a really fruitful conversation and really interesting. So we thank you very much for taking the time to talk to us. It's been a real pleasure.
Well, thank you for doing that. And I'm sorry I didn't mention students. I meant to mention students as well, but you can see yourself as included amongst activists, if you like. Because it has been students that have inspired me from the beginning. There's been much more interest in what I've been talking about amongst students than there has been amongst my senior colleagues in the early years. And there is no place that I've seen the change that has happened over the last decade or decade and a half as clearly as I have seen when I'm speaking with students. So keep up the good work.
Thank you. Yes, so that was our interview with Professor Beate Sjåfjell. I think this was a great interview because she has such a powerful and coherent critique. I don't know what you took out of this, Iva?
Yes, I agree with you. I have few things to emphasize. First, professor said that when Norwegian state decided to give licenses, that decided to continue to give licenses, that they practically went beyond what they had discretion to do, and that was a clear violation of the Constitution and the Paris Agreement, which is maybe interesting to connect to the fact that Norway was once country which brought the principle of sustainable development and now is destroying its reputation, as the professor said. Maybe as a final thought, I like the description of a legal activism as a piece of a puzzle together with media and courts and politicians and so on.
Yeah, because she really had a direct and condemning comments of the court and their decisions. So I think that was just really great and interesting to listen to all the knowledge she has on this topic. And she also talked about the weakness of the environmental report, and I think that's also extremely interesting, which is why in the next episode we will be talking to two economics professors just about this impact report that was done before opening up the fields. So please join us in the next episode to learn even more about that.